confusion. Is the hand down in court or is the hand down remote? Do you know?
There's a hand down at 2, isn't there?
Is that?
Or is that? Yeah, sort that out.
I've got a little bit more space in there.
A little bit further.
Did you get the silk?
Yes, exactly. Right. Somebody's moved these around.
Have you got Arnold's direct number? Yeah.
See all these books on the walls and they're completely redundant. Just throw them away.
Do you still get RPCs and office hours?
I abandoned those a few years ago. I had them for a while and
There is. I
discovered
want to
I
know
was looking at them.
whether it's been listed as remote or.
Look at them. And then I
But do you not look at them on the
No,
screen or
people-
not look at them?
I do look
Don't
at
it
them.
show?
And then I got
On the court,
and then I
yeah,
still
fine,
have
yeah,
some
fine.
bound.
On the
I've got
causes,
them
we've
bound,
got to
and then
have
someone
judgment
borrowed
hand
some of them, so
Well,
it's
that's
missing at the end.
Yeah. Yeah.
I'm just funding people in chambers to steal
Yeah, because
loose
when
copies
it
of
went
the
out,
RPCs.
started,
You know, Geoffrey
didn't go
Hobbs
out
has
with the
corners of
COVID
his textbooks.
remote.
Um,
So
carrier.
that,
So we're thinking we're going to be
if he
handing
walks
it
into
down in
someone
court.
else's room and there's a
But
copy
it's
curly on the
listed
desk,
as
for example,
remote.
that's mine. And
How
then
does
so,
that
you know,
place it? How does that place
What do you
it?
no, he just chops through the cover.
What's wrong with using a stamp?
Well, that's what he said to me anyway.
Of course, yeah, I will do that. On normal
Yeah, what's
circulation,
wrong with the
but-
stand?
But the court station hasn't got the detail, has she? She hasn't got the detail, has she?
You did,
So if I give her a copy of the judgment, yeah.
So I'm running around looking for my hole punch
Okay,
in the last
yeah, thanks very much.
year and a bit.
Bye.
Somebody's stolen my hole punch.
She said, can you call this on?
Terrible.
But it's called on as
Yeah, George Wilson's went up.
round
Exactly.
and others. Okay.
I'll have to go through every room now to find where my hole punch.
I did read that the most stolen textbook is Archibald.
Is it? Oh yes.
Which is slightly ironic.
Exactly. That's not client stealing it, but something to read in prison.
And you're planning your appeal.
There will be judgment and down before we go back
Okay.
into the afternoon.
Okay.
Is that all right?
Oh, that's right.
Right, hang on a second. And I'll send it electronically anyway, so don't worry too much, but I'll give it to you. Okay, let me see where we are. I'll come in behind. Yeah.
So Geoffrey Hobbs is next door, he said. Trying to overturn. Crikey.
Oh, really?
Yeah.
Court is ready, yes?
Yes. Court rise. Judgment between Charter Training Limited and Matthew Anthony Ralph and others.
For the reasons given in the written judgments which I now hand down, we have decided that the shares in question were not issued at a discount, either for the purposes of Section 580 or Section 552 of the Companies Act 2006. In consequence, the appeal will be dismissed for the fuller reasons contained in the judgments. In the light of the draft judgments, the parties have agreed an order, save for the question of permission to appeal to the Supreme Court, which is refused.
I was going to take you to Gore itself.
Yes.
This is tab 1 of the supplemental bundle. And it's quite a long pattern tonight. I'm only going to just take you to a few passages in it. The first passage I want to direct your attention to is on page, well, it's page 3 of the bundle, top right, so it's the second page of the first page of the patent.
Yes.
So there's an errata sheet, and if one starts at in the left-hand column at 35, it says, according to the present invention, there's provided a porous polymeric material containing units derived from tetrafluoroethylene, the material having a microstructure characterized by nodes interconnected by fibrils, the material having a matrix tensile strength as defined. So that wording, microstructure, nodes interconnected by fibrils, is what the words of the Hoare patent application use. So you can see why paragraph 17 of Hoare uses that terminology. And then the next paragraph is further, according to the invention, there's provided a process for the production of porous polymeric material, and so on and so forth. And if we look at line 50, it talks about stretching the shaped article at an elevated temperature and a rate exceeding 10% per second of its original length. And the point about Gore, the Gore-Tex patent, is that what you do is you stretch PTFE very quickly, and surprisingly, what one finds is one gets this structure with lots of very, very tiny holes in a nutshell. There's a little bit more detail about what you get on the second page, page 2 of the patent itself, page 4 of the bundle, starting at line 94. I won't take you all through it, but it says the precise form of the porous microstructure generally depends on the temperature and the rate at which the polymer expands. So it's telling you can change things in that way. At line 103, the fibrils which interconnect the nodes are substantially parallel in the direction of expansion. They appear to have characteristic maximum and minimum cross-sectional dimensions, the maximum width usually being about 0.1 of a micron being a millionth of a metre or a thousandth of a millimetre, which is about the diameter of the crystalline particles, and the minimum width usually being 1 or 2 molecular diameters. And then it says the nodes may vary in size from about 400 microns, so that's about 0.4 of a millimetre, to 1 micron, depending upon the conditions. And then it goes on to explain a little bit more. But the point is that the process describes that you can get quite a range of these materials depending upon the process conditions you use. Over the page at 3, I think this may be a passage which one's looked at before. Page 3 of the patent, line 105. The materials generally have permeabilities to gases, and in some cases to liquids, which are much higher than those of conventional moulded or extruded PTFE. Then over the page at 4, line 98, it then talks about the 2 drawings or 2 figures.
Sorry, line which?
Line 98.
Yep.
Figure 1 is a plan view of a section of the polymer, and figure 2 is a view of the apparatus. It might just be worth glancing at those. Those are on the last page of the document. And one can see from figure 1, the blobs are the nodes and the little strings are the fibrils. And figure 2 is showing a really schematic diagram of a machine. And essentially the rollers move at different speeds so that the material is stretched. And then there follow a number of examples, and in some instances details of permeability to air are given, in few instances of permeability to water given, or liquids, some instances references made to kerosene. And example 10 is just one of those numerous examples. As I say, the claimant the defendant made no attempt to show that everything made according to the Gore process would inevitably infringe. Couldn't do that. It's unlikely that it did. because of the wide range of materials you can make, and indeed, Hoare is telling you specifically that you can use the process to make something which is vapor permeable, but liquid water impermeable. And for that reason, while of course paragraph 17 refers to Gore, it is not a direction that any particular example will work. As I said, it is simply a direction that you should make the layer vapor permeable but liquid water permeable. One way you can make that is by, e.g., Gore, the Gore process.
So are you saying then that the cross-reference is as susceptible to being interpreted as a reference to the process described by Gore as it is to any of the products disclosed by Gore?
Indeed, the process and the general nature of the product, which is, as shown in figure 1, nodes with fibrils, it's susceptible to, indeed that is the only statement that is made. There's no direction or promise that one should use any particular example. It is simply saying what, and this is exactly what the words of paragraph 17 say, is you want a microstructure, nodes interconnected by fibrils. And if you want to know how to make that, and if you want some more details, read Gore. And so for that reason, we say that what Fiberweb is trying to do is an impermissible exercise of simply looking at the target and saying, well, if you ignore what Hoare says and choose example 10, you may get something which falls within the scope of the patent. But the difficulty is it ignores exactly what Hoare has told you to make. And that's, we say, the simple answer to the novelty over Hoare point, and it's the answer given by the judge, and it's the answer we invite you to adopt in your judgment. My learned friend showed some authorities. The one he referred to particularly was Dr. Reddy's, in which Lord Justice Jacob talked about what I was looking for was an individualised description, but that was in a different context. But in any case, this is not a case of an individualised description. It's a generic description. What you want is a product, nodes interconnected by fibrils. It's taking the reference much too far to read it as saying that each and every example of Gore is one that you should use, or you could use.
Let me rephrase that in my own language to see if I've understood your submission. Your submission is that when you read paragraph 17 of Hoare, that is a generalised description.
Yes.
And the fact that by the time you get into Gore and arrive at paragraph example 10, 10 is in its own context. An individualised description is neither here nor there.
Yes, that encapsulates my submission. The question is, does paragraph 17 of Hoare contain an individualised description? And the answer is it doesn't. It contains a generic description of the type of product and possibly the type of process that might be used. And we say that's therefore the end of the novelty point. Now, Lords, I've been very quick, but I don't know if there's any more points I can assist you on, but those are the submissions I wanted to make on the subject of Hoare and Gore.
Thank you very much, Mr. Hicks. Yes, Mr. Turner.
My Lord, I wanted to start with construction. My learned friend, perhaps somewhat opportunistically, has built his case on a suggestion that the weight of the track is not relevant and the ballast is not relevant to the question of whether water permeates from the subgrade into the subbase. That is just not relevant. This theory was not said to be part of the common general And if one looks at the common general knowledge, it's obviously set out by the learned judge, but it's also in agreed documents. And we can see those at tab in the supplemental bundle, tab 13. There was because of the complexity of this case, there was a requirement for the parties to agree on common general knowledge. I think I showed you that already. And then it's also at tab 8. There was an agreed a joint expert report from the two experts.
Want to look at tab 8 or tab 13?
So there's tab 13,
Tab 13.
which is an agreed statement of
Yeah.
common general knowledge. And then at tab 8, there's a joint expert report,
Right.
which sets out agreed areas of common general knowledge and indeed disagreed areas of common general knowledge. And nowhere in those documents will you find a suggestion that the weight of a track and ballast is not relevant to the question of whether water permeates.
How far do you take this submission? Because the list in tab 13 doesn't include Newton's third law. So you say that therefore we have to disregard Newton's third law.
I'm saying Newton's third law does not apply to this situation. That's what I'm saying. And my Lord, one needs to bear in mind that although this is a static load, this is not a static system.
Not a static?
System.
No, you've got trains passing by periodically. That's the
Yeah.
whole
But
point.
you've also underneath, my Lord, underneath the subgrade, what's going on? What's going on in the subgrade? You've got water. We're not just talking water permeating from the top of the track. Water coming down sidings, you've got underground rivers, you've got environmental conditions affecting the amount of water in the clay. It's not a static system, it's a dynamic system, plainly. And if we go to the judgment, that's paragraph 133. This is the judge saying that I've rejected Professor Ingel's theory that the pattern does not work, was water will fall laterally sideways. That's the, I would have heard about that. I've also found that the clogging blocking was one possible explanation put forward by Mr. Saxer for what both parties conceded was a very complex interplay of forces beneath the geotextile. It was not and it was not advanced by my learned friend below, but as a technical fact, the question of whether of the load of the track and the ballast is not relevant to whether water permeates from the subgrade into the subbase. It was simply that case was never developed, and my learned friend has sort of jumped on it somewhat opportunistically today, if I may say that. If we could just keep in mind one is coming to this patent specification, and of course it's not a matter for the experts to construe it, it's a matter for the court. And one needs to put to the back of one's mind any idea that somehow these loads aren't relevant. One doesn't come to the patent with that as part of the common general knowledge. One comes to the patent without that, and then one just has to read the specification. And if you start just going back just a couple of bits, obviously we've been through this, I'll take this extremely quickly. But again, picking it up at 11.
Well, you say this wasn't advanced below.
Yeah.
But according to Mr. Hicks's skeleton argument, your expert himself said this, so why would he have submitted anything to the contrary? So if you look at paragraph 29 of Mr. Hicks's skeleton argument in this court, 4 bundle tab 3, page 43.
Sorry, my lord, I just need to, I know the passage, my lord, so paragraph 29.
Yeah. So he quotes paragraph 35 of Professor Ingold's report. The reason that the track loading is not relevant is that it's a one-off load applied when the track bed is first constructed. The poor water pressure differential introduced by the installation is dissipated once and does not need to be considered again. And then there's the passage in cross-examination that Mr. Hicks relied upon in his submissions before a shorter jump.
Yes, so, my lord, there was a great deal of evidence below about how these things were working, and Professor Ingold was very unimpressed with this pattern. There's no doubt about that, and that's why he said it was insufficient, and he says it would not work according to the teaching in the patent. And I showed you some passages of that in the judgment, and the judge rejected that. What Professor Ingold wasn't saying, and certainly what the judge hasn't found, is that one comes to this patent with the knowledge that the weight of the track is irrelevant as a matter of common general knowledge. That's simply not the case. So picking out, as my learned friend seeks to do, little snippets of evidence which are not common general knowledge, which form the basis of an insufficiency case which then failed, this cannot be relevant to construction of this patent. In particular, when the judge rejected them, and then at 133 says, look, you know, it's complex, and I'm not making any findings.
But as my lord says, I mean, does it have to be common general knowledge in the technical sense to know about Newton's third law? I mean, I don't suppose the common general knowledge records that water doesn't flow uphill. But
Yeah, no, my lord, absolutely it doesn't, of course. I'm not saying that Newton's third law is not common general knowledge. What I'm saying is, does Newton's third law apply to this dynamic system? That's the basis on which the case is being put before you today. It was not the basis the way the case was put before the judge, and it's not in the judgment.
Right.
Simply not. And one can theorise lots of reasons why that wouldn't apply, but the fact is it was never suggested below that you come to this patent specification, you see the reference to the load of the rails and the ballast, repeated references, which we'll have a look at in a minute in the specification to it, and then you say, well, the patentee doesn't mean that because of Newton's third law, or for any other reason. And Newton's third law simply doesn't apply to these circumstances. Of course it doesn't. It's a dynamic system. You've got water flowing everywhere. Of course it's not. It's nothing to do with Newton's third law. So, as I say, you know, Professor Ingold just didn't like the patent and didn't think much of it. But he wasn't, you know, it was never put that you'd read these passages that we now rely upon and ignore them for a technical reason. And so going back to 11, we have that definition of normally permeable to liquid water at the start of the line. And then if one goes down to line 54, it will therefore be understood that the load of the ballast, sleepers and track, so that it is a relevant load, located on the liner will generally not be sufficient to cause liquid water to pass through the filtration layer. In other words, the pressure exerted by the trackbed liner upon the trackbed liner by the ballast, sleepers and track is not sufficiently high to cause liquid water to pass through the filtration layer. Now, my learned friend asks you effectively to put a line through that and say that the skilled person ignores that and thinks that the load of the trackbed liner, ballast and sleepers is entirely irrelevant. And then if we go on, we see the reference to these various figures. I'm not going to take them everywhere, but the 5 kilonewtons, which is just above the load of the trackbed liner. These are all serve no purpose at all, according to my learned friend. And then gets to 53, and we see a reference, sorry, 54, I beg your pardon. We see a reference in the first part of that passage saying, however, this is the second sentence, however, in use and under the load of a vehicle, the filtration layer permits liquid water upwardly there through, but restricts the passage of solids. That's obviously when the train is passing. And then coming down to line 22, furthermore, the liner permits passage of water from the clay subgrade into the ballast, which occurs during the passage of the train along the track, providing watering effect. Water flows from the subgrade because the pressure exerted upon the liner as the train passes over each sleeper is sufficiently high to force the liquid water upwardly through the pores of the filtration layer into the ballast. However, following the passage of the train, when the pressure acting on the filtration layer reduces and is then due only to the load exerted by the trackbed and track, the filtration layer 30 once again becomes impermeable to liquid water. So the patentee is plainly contrasting, we say, the loads of the trackbed with the loads of the trackbed when a train passes. And again, looking at 56, the same thing. However, the inventors believe that water will primarily or entirely be transmitted through the filtration layer, liquid form. The water transmission occurred due to the increased pressure exerted on the filtration layer when the train 34 passes along the track, and tells you typical static loading on the filtration layer would be less than 10 and maybe approximately 2.9. According to my learned friend, all this is to be struck through. There's no relevance whatsoever to this case and to the construction of the patent. My lord, we say that that is not a credible construction, and it is built on a technical assumption that the skilled person thinks Newton's third law is relevant to interpretation, and that has not been made good in evidence. It was not a submission before the judge, and it is not referred to in the patent, nor it cannot be a relevant consideration. And my lord, has to be, we would urge caution in being sort of opportunistic in or seeing my friend's submissions as anything other than opportunistic, arising from a question from the bench. My lord, then if I can go on to novelty. And my lord, we are dealing with, we say, an individualised disclosure. And as I said in opening, but it needs to be kept in mind, one can have more than one individualised disclosure. So if you have a list of 30 things, each one can be an individual, is likely to be an individualised disclosure. So 30 things in the prior art, for example, just to illustrate the point. But if you have a single thing which may produce 30 different results, then you fail on the novelty test. That is different from 30 individualised disclosures. So if you have a recipe, and depending on how you perform it, you may get 30 different results. That's not inevitability, but 30 distinct recipes, each of which give you a different thing. Any one of them may be an individualised disclosure. That comes out.
That would be so, would it, if the cross-reference says you can use any one of these 30?
Yes, if you can use any
even though only one of them actually would infringe.
Yeah, no, that would absolutely be novelty destroying, certainly, yes. But there comes a point, as Lord Justice Jacob pointed, Dr. Reddy's, when you start saying it could be any one of 80,000, or when you're losing the leaf in the forest, so to speak. So the intrinsic, if we just go back to Hall, and just, so last time I promise, tab 2. And just look at the problem that's being solved. So you're told about the problem, if you recall, about pumping erosion in paragraph 4. And then the object of the invention is at paragraph 5 to address this problem of pumping of fines. So you want to stop the fines. That's clear from going from the sub-base, from the subgrade into the sub-base. And then if one goes into paragraph 15, I think my learned friend said that the Form A doesn't do that. I don't think that's quite correct, because it goes from something that's completely permeable to something with slits. If you look at 15, so this is looking at embodiment A, just says down towards the end, there is a water impermeable region on the lower flexible sheet around which each of the load spreading elements. Such an arrangement serves to minimise any local pumping. So, of course, my learned friend's perfectly right. You've got some gaps in there, and there will be some pumping, but you're minimising it by now having just a small percentage of the surface area permeable. That's how A is working. We're, of course, concerned with B. And important to note, we're not talking about the trackbed liner. We're talking about the material. So in the case where the lower flexible sheet material is a type B material, i.e. water permeable but substantially permeable to liquid, so it's talking about the material there, not its properties or not its behaviour in situ. Such might be a composite sheet formed of para-adable permeable textiles, etc. And the fact it might be a composite sheet, still an individualised disclosure of a composite sheet. And then it directs you, and the judge you incorporates the disclosure in 373. So you go to 373. There's no reason for rejecting example 10. So if you go to example 10, it's the only material, as we've discussed, which is impermeable. And of course, it's there to filter out. It's a filter membrane, which of course is precisely how you're addressing the problem of fines.
Can I just be clear as to the facts on the different examples?
Yes.
Mr. Hicks didn't contest that example 10 is the only one which is described as having some degree of impermeability.
That's correct.
But what he said was that there's some examples that you can't tell. Do you accept that?
I think that's probably correct. Some may be unclear. It was obviously put to the witness as well. You saw that cross-examination. But it may be the case that some of the examples don't say one way or the other.
Thank you.
But my case, if there are 10 examples, I'm not sure how many there are. If there are 10 examples and some of them work and some of them don't, by work I mean fall within the scope of the claim and some of them don't. If indeed there is an instruction to go to those examples, 1 is good enough. 1 out of 10 would be good enough because that's an individualized disclosure, and that's no different, my lord, to saying in a sort of chemical, when we're talking a chemical compound claim, where you've got a claim of a certain breadth and you've got 10 molecules listed in the prior art. You don't avoid novelty by saying, well, 9 of them don't fall within the scope of my claim if the 10th one does. The 10th one destroys the novelty, because it's an individualised disclosure. So my lord put to Mr. Hicks, and it's a fair question. Look, are you being directed to Gore to do anything more than adapt the general technology, or are you being referred to specific examples? And I think that is, if I may say, that's the crucial question. But we say it's not as simple as that, because clearly the direction to go to Gore would include the examples. So you can say, well, look, there's a direction to go to the specification and use the technology directly, but also to have regard to the examples. And example 10 satisfies, on my submissions, satisfies exactly what you're looking for in paragraph 17, because it's a material which is impermeable. And to say that that's not an individualized description is, artificial, because effectively you end up with a patentee patenting something which has been taught before. I think my lords understand the point. I probably can't repeat it anymore, or at least I won't assist you if I repeat it anymore. Can I just check if there are any other questions? No, my lord.
Yes, thank you, Mr. Turner. Well, thank you both very much for your very succinct arguments. It will not surprise you to learn that we will reserve our judgments. You'll get a draft in the usual way, which will be your opportunity to correct typos and any obvious errors. We hope that in the light of the draft you will be able to agree a form of order disposing of the appeal, but if you can't agree a form of order, please make short submissions in writing and we will make the appropriate order. Thank you both very much.
Thank you.
Well, right.